Daily list item number 1, pronouncement of judgment.
So, Mr. Jindal,
Madam.
I'm very sorry, but
Madam.
this court cannot agree with your contention.
Madam.
So, of course, I've modified the ultimate award,
Madam.
taken the annual income as 40
Madam.
instead of the 60, and interest, of course, reduced to 7%. You have not exactly contested the claim of your liability.
No, we haven't. We haven't.
So accordingly, in view of the above findings and observations, this court would modify the impugned judgment and award by assessing the award of compensation to the claimant as follows. This is the table I've given. Accordingly, this court finds that the claimant is entitled to fair compensation calculated as above, that is 7,02,000 along with 7% simple interest per annum from the date of filing of the claim petition to realization of the same. The rate of interest being taken as the comparable rate of interest presently applicable.
Well.
So you have to satisfy this award within 2 months?
Madam.
Unless you wish to go up?
I don't think so.
It's more hassle than anything else.
It does. Published.
Thank you.
May I please, Your Lordship? Your Lordship, I beg to mention item number 7, Your Lordship.
Why?
The conducting counsel is not available today. Your Lordship, I pray if this matter can be fixed tomorrow, Your Lordship. It's a part-heard matter, Your Lordship.
Part-heard matter, that's what
Yes,
I...
Your Lordship.
What is required here?
Your Lordship, we had to sort for clarifications regarding their submission, Your Lordship, on the last date.
Is it on areas? No, they are not claiming areas.
It's a service matter, Your Lordship.
Yes, not areas of pay if notional promotion is given. If
Yes, Your Lordship.
and the areas of pay or financial benefits.
Whether we are entitled to that, Your Lordship.
Yes, Your Lordship.
You are entitled, but you are not claiming.
Your
That's what
Lordship,
I'm made to understand.
if it can be fixed tomorrow, Your Lordship.
On prayer made by Miss Leonard G. This is matter tomorrow.
Much obliged, Your Lordship.
Daily list item number 2.
Mark, you have responded.
Yes.
Please, Your Lordship. There is a caveat, Milord. I think Mr.
What is this matter about?
Milord, that Your Lordship will recollect that airport land acquisition, Milord.
Oh, okay.
So, Your Lordship had handled it in the division bench. So, thereafter, Milord, according to the last order of the Honorable Division Bench, that we were given 8 weeks' time to agitate against the report of the Shillong Court. So, we have come challenging that order of the Shillong Court, Milord. We have come under Article 227 of the Constitution. So, there is a caveat because, Milord, why there is a caveat? Your Lordship will, I'll take Your Lordship there.
But before that, Mr. Of course, I may be wrong also, but the matter was dealt with in DB.
It was dealt with.
I was
Yes, Milord.
one of the
Yes,
judges who had passed the order. because we had directed matter to be, if parties are agreeable or aggrieved, we can agitate, before the competent.
My lord, my lord.
Now, same subject matter is coming before me
Yes, yes.
as in single bench.
My lord, my lord.
I don't know.
Because Justice Bhattacharya could not take it because he had appeared in this case when he was an advocate.
No, as far as I am concerned, that's only, I would seek your advice on that. Since you are a senior advocate, or Mr. Shulai here can advise if it is.
Miller, in the DB, the merits of the report of the Shillong court was not considered. The merits will be considered now, Millard. Shillong court had given the report and the Honorable DB just gave us the scope, the opportunity of agitating as per law. But entering into the merits, whether that report or that judgment of the Honorable District Judge at Shillong, whether that on the merits of that the Honorable DB did not go. So in my humble understanding, there is nothing wrong. My friend is also there. In my humble understanding, there is nothing wrong in your Lordship taking it up.
May submit, madam. This matter, Mr. Paul is appearing for the respondent number 3. Lordship, I am kindly praying if this matter will be taken up at the end of the board, madam.
Only that small, I would say nickel.
As far as I am concerned, Millard, I don't see any hurdle in your Lordship taking up. And Mr. Paul is also there. And
Lordship, there is also a private respondent number 4.
yes.
No, that is, we are not going to that.
Lordship.
If that is the case, of course, notice has to be issued.
Notice
Also,
to be
that will come later. But only thing at the inception. If this court,
Whether your Lordship will take up or not.
it cannot take up, then it can't take up. But if it can, then why not?
As far as I understand, there is nothing wrong.
Perhaps.
Yes, my submission is division bench didn't go into the merits of what is challenged before your Lordship now.
Because only, I mean, according to me, I may be wrong, like I said. The only thing is that since this court is seized of the matter in the DB, perhaps.
In the DB, Millard, the DB acted as per the direction of the Honorable Supreme Court. Then the process was initiated. Initially, inquiry by Nongpo. That report came. Then it was referred to the land acquisition under the land provisions of the Act. And then the Honorable District Judge submitted the report. So the Honorable DB has never gone into the merits of the judgment and order which is assailed before your Lordship. That is of the. So I feel that there is nothing wrong. In fact, my Lord, it is a boon. It is something good that your Lordship is already aware of the facts of the basic facts, at least.
Yes, yes.
Basic.
So we'll wait for Mr. Paul then.
Let Mr.
But,
Paul come. Let
if that is the okay. End of the board.
End of the board, or if Mr. Paul comes earlier.
Whatever, we'll see how the cases proceed.
Item number 3.
348. Morning, Your Lordship.
Yes.
Lordship, if I may. Lordship, item number 3 has been placed before your Honourable Self. Item number 3 and 4 connected matters, Your Lordship. Same case, same set of circumstances. And there is an item listed at number 8 today as well. They're all from the same case, Your Lordship.
Lordship, item 348, Your Lordship, arising out of the same case, Your Lordship. In one of the keys, Your Lordship, that is in bail application, Your Lord.
44. Damanbar Ripnash.
Lordship, at page 61, Your Lordship. Lordship has dealt the
Page 61 of
Page 61 of
61 of the
item
bail
number
application.
8. Which one are you holding, sir? Sorry. Item number 42 only. Bill application 45, Your Lordship. The one which is
yes,
before.
yes.
Item 3, Your Lordship.
So you mean to say that the subject matter is identical in all three?
Parametry, absolutely, sir.
That is
Arising out of the same FIR, Your Lordship.
All these individuals are arrested together on the same day, Your Lordship. Same forwarding report.
grounds of arrest not informed.
Same forwarding report, same demand report for all of them.
Mr. Shulai,
Lordship,
earlier you said you will need some instruction here.
For item number 8 is.
Lordship, the instruction I have been informed that there is a move to go further, Your Lordship, to challenge this order. But I don't know whether that has been filed or
That
not.
you can do.
Lordship, yes.
That definitely you can do. But as far as the the order,
It remains. Yeah, it will govern. It will govern the field, Your Lordship.
because
Since Your Lordship has given a finding, Your Lordship.
similarly, in fact,
Yes.
same case.
Lordship, yes.
Same forwarding report, same demand order.
Since Your Lordship has dealt with that earlier
course,
matter, Your
yeah.
Lordship, I'll not.
There are parts of common order.
Lordship. In case the state goes to the
Yes.
subcourt,
Then, in fact,
that
if-
is a
if-
different
if-
issue,
yeah,
Your Lordship.
in fact, if that is the case, then
Lordship,
you will get the opportunity to come against the previous order and as well as this order.
Lordship.
So it'll solve, everything at one go.
Together.
Ketuk common order. I get to brought likely 2, 3, but 8.
3, 4, and 8.
348, Your Lordship. 348.
3, 4, 8. Heard Mr.
So, last details.
S.S. Yadav, Learned Counsel for the petitioner. Ashwaktu. These 3 petitions have one common aspect, that is all 3 are related to the other cases under is it under investigation
It's
or
charge sheeted, Lordship.
charge sheeted
Already charge-sheeted, Your Lordship.
or charges not framed?
No, not yet.
What's the case number, Mr.?
UAP case number 1 of 2024, Your Lordship.
Kunung Tungau?
Correct, just check.
61, page 61.
To the case considered in special UAP UA under bracket P case number 1 of 2024
Okay, 1.
before the Court of the Learned Special Judge UAP River District Nongpo. The genesis of the matter stems from the lodgement of an FIR. Where's the FIR?
FIR, Your Honours, with Nicholson's bail application. FIR is at page number 10.
FIR dated there's no date here.
11th of March 2024. It's there, Your Lordship.
FIR dated 11 March 2024 filed by 1. Inspector Sim Seng A. Sangma, in charge Special Operation Team, East Khasi Hills District, before the officer in charge Nongpok Police Station, River District. The facts of the case indicated in the said FIR is that on the basis of an IED blast at Syndicate Bus Stand, Punjabi Lane, Shillong, at around 11:30 p.m. or so on 9/3/2024, some person suspected to be involved in the said incident have been arrested, and a case was also registered as Sadar PS case number 83/2024 under section FIR. The next one, the arrested person namely Shri Damanbha Ripnar. Who else? How many were arrested here?
Total 4.
Four person in law.
All 4 have come before this court.
Yes. So Robinus has been granted bail. The other 3.
That's apart from Ruvinus.
Yes.
So Damanbha Ripnar, and then the other one.
Lordship will find it at page 14 of the petition, Your Lordship.
True, Your Lordship. Easier.
Damanbha Ripnar, Nanta, Ruvinus Ripnar, Shining Star Nongrum, and Nishalson Taryang were arrested and charged under the relevant section on the IO, on the investigating officer filing his charge sheet implicating the above named persons. The case has been sent up for the said accused persons have been sent up to stand trial in the said case number 1 of 2024. However, it is admitted that till date charges have not been framed against the said accused persons. Next, in the meantime, one of the accused persons, Sri Ruvinus Ripnar, had approached this court with a prayer for grant of bail, mainly on the ground of technical defect in the process of his arrest. That is, that he was not informed of the grounds of arrest at the time when he was intercepted and arrested in connection with the said case. This, according to the said petitioner, is a violation of, firstly, the provision of Article 22(1) of the Constitution of India, read with Section 43(b) of the UAP Act 1967. Next, this court, on consideration of the submission and contention raised by the parties, that is the learned counsel of the petitioner and the learned AAG, had granted bail, had allowed the petition and had accordingly granted bail with conditions to the said Sri Ruvinus Ripnar. Now, at the present, Sri S.S. Yadav, learned counsel for the petitioners, all the petitioners have again approached this court, making similar submission and contention, more particularly seeking bail on ground of parity, inasmuch as even the three accused person in these three separate applications, though they were arrested in connection with the said case number 1 of said Ashok ketuka case number 1, they were never informed of the grounds of arrest at the time when they were arrested. Hence this petition and prayer therein. It's accordingly prayed that this petition will be allowed with any and bail may be granted to the petitioners, to the respective petitioners, with any condition to be imposed by this court. Mr. N.D. Shulai, Leonard AG, in all fairness, has submitted that the prosecution have no objection to make at this point of time in view of the related order passed by this court in the case of Shri Venus Ripanar, wherein by order dated 26/8/2025 in BA number 38 of 2025, this court, as has been noted, has granted bail to the said petitioner, and the three petitioners herein being identically situated. Therefore, there is no scope of objection at this point of time. It is prayed that necessary orders may be passed with this court. Anything else?
Lordship, only certain condition may kindly be additional condition, your Lordship, like the Lordship, in case of non-compliance with the condition laid down by this court, then we are at liberty to file for cancellation of the bail, your Lordship. If Lordship can, in the earlier order,
Okay.
In the earlier order, your Lordship was pleased to set out 4 conditions, your Lordship.
Okay. It's accordingly. Accordingly. Accordingly, in view of the submission made for this court, this court is inclined to allow the petition, the prayer made by the petitioners, and directs that they shall be released on bail forthwith if not wanted in any other case or cases on their compliance with the following condition. It is further directed that I know next paragraph also. It is the further direction of this court that in the event that any of the conditions set forth is breached by the petitioner, the prosecution can move the trial court for
Lordship.
cancellation of the bail.
Lordship, I am highly obliged, your Lordship.
Petition disposed of. No cause.
Highly obliged.
Obliged, your Lordship.
Good day, Lordship.
Item number 5.
Eh? Ang tu kerja itu condition baru sakli. San forward.
Wait, please, Your Lordship. Lordship, I'm praying for some accommodation in this matter on behalf of Mr. Sen. Due to some personal difficulties, he's not available today, Lordship. I'm praying if this matter may be listed day after tomorrow, Wednesday, Lordship, as per the convenience of this honorable court.
No objection, Lordship.
You are there. Mr. Leonard G has sought for accommodation.
Otherwise, let it come on Friday or no, together. Mr. Is Mr. Sen will be available on Friday?
Make it on Thursday, Lordship.
When will he be available?
Because as per my instructions, he had requested for Wednesday, Lordship.
Or else we can have it on Thursday.
Thursday. Oh, Friday. She said Friday.
Friday. Let it come on Friday. If Sir Sen is available, then we will do it on Friday. Otherwise, it will come.
On Thursday, Lordship.
Friday, you're going fishing. Okay. On Premier Hunuto. On behalf of Mr. S. Sen Leonard G, who is conducting the matter, as he is indisposed for the day. Accordingly, as prayed for by the parties, list this matter on Thursday.
Hello, Branch.
Item number 6.
Lordship, in this matter, we've taken steps.
Yes.
From the website is showing that it has been delivered to Nigrims SO. Because all the residents are from Nigrims, all the respondents. They're residing as per the address in the claim petition. They're residents of Nigrims. So we've taken steps, Your Honor. It is reflecting that it has been delivered to Nigrims. But AD card is yet to be received by this honorable registry.
Yes. So you see, you get the, as usual, extract of the postal confirmation.
Yes.
And file an affidavit of service.
Yes, Your Lordship. Your Lordship, in the meantime, Your Lordship, the interim stay may be continued, Your Lordship.
Is there any interim order?
Yes, Your Lordship.
Where is the interim order passed? No interim order is passed. You file any miscase?
Yes, Your Lordship. Miscase is there, Your Lordship. Your Lordship, order dated 22nd 8 2025, Your Lordship. In miscase 4 2025.
Yes. Mr. Counsel for the appellant has submitted that the notice issued upon respondent's number, all the respondents,
All responses, Your Lordship.
on all the respondents have been affected. However, the Learned Counsel has fairly submitted that the ED card have not yet returned or acknowledged by this court, by the registry of this court. It is prayed that some time may be allowed for the appellant to confirm issuance of the said notices and also to file an affidavit of service before the next date fix. As prayed for, this is matter of 2 weeks.
Obliged, Your Lordship.
Second call, item number 2.
Yes, Mr. Paul, we're waiting for
Insofar
your
as, my apologies, Milids. Insofar as this matter is concerned, one of the orders, Milids, which confirms the order of the learned district judge, Milids, was part of the composition of the division bench of this honorable court. Now, Milids, whether my lords would be pleased to take up this matter, especially, Milids, again, there's another facet to this entire matter, is one of, my lords, the parties in this litigation has carried that order passed by my lords in appeal before the Honorable Supreme Court. That is registered as SLP Civil number 24637 of 2025, my lords, which is likely to come up on this coming Friday.
Concerning the said report.
My lords, the orders passed by my lords sitting in division bench, my lords, has been carried in appeal.
Okay, wherein the
This order, my lords, I'll just point out.
wherein the report was accepted.
Accepted, my lords. That order has been, where my lords have treated that as an original decree,
Yes, yes.
that order has been carried in appeal.
Oh.
24637. Well, I would only humbly submit.
Mr. Chakravarti, in that sense, you see, then it will have some consequence in your instant application. If any order passed by Supreme Court, let's put it that way, it may have a cascading effect.
Milan, that would be, of course, there, but as of now, there is no order of the Supreme Court.
No.
So that would come in the final thing. Milan, here the only urgency is this, Milan, that in the last part of the order, Milan, that we direct 20% of the component, that aspect, if your lordship recollects, at page 207. 207.
8 weeks.
8 weeks time, Milan. The last part of the order, Milan, we only clarify and direct that 20% of the compensation amount which is withheld by the state will continue to be withheld for a period of 8 weeks from date, after which it shall be released to the said transferor if there is no order to the contrary. The period between 20th June 25 and pronouncement of this order shall be excluded in calculating. So only because of that we are under a little pressure. Time constraints are there.
Well, 8 weeks would otherwise also expire on the 23rd of September.
Not 23rd. I think
8
our,
weeks.
our calculation is being
23/7.
over on 17th.
No, 23/7. Roughly, Milits.
23/7.
So 8 weeks from 23/7 would be somewhere around Milits 21, 22, maybe a day or two here and there.
Could be. Yeah, maybe 21, 22. Whatever.
But as far as I know, the Supreme Court before the Honorable Supreme Court, the matter has not been listed till now. It has not been listed. Mr. Asu's client went there, State Dakar, and the matter has not come up at all till now. When it will come up, we cannot say, because in the Supreme Court they do corrections and all that.
True.
It is time-taking affair. Milord, I would submit, Milord.
One thing is,
Milord, if I may move the matter, your Lordship may consider my prayers. In the meantime, Milord, if anything comes from the Supreme Court, then the matter will automatically.
of course, that is also one way of.
Automatically, whatever, if Supreme Court interferes in any manner whatsoever, simply pending before the Supreme Court would not be a constraint on your Lordship.
That is well settled, of course.
Milits, if I may just clarify, pendency before the Supreme Court is not an issue. Issue here is, Milits, my lords passed an effective order sitting in division bench. That matter, Milits, has been carried in appeal before the Honorable Supreme Court. That's the position.
My Lord,
Now,
in my humble submission, Milord, as I had submitted earlier, your Lordship, when my friend was yet to come, your Lordship had already inquired whether this matter can be taken up at all. Milord, the order which was passed by your Lordship sitting in division bench has not gone into the merits of this report of the district judge Shillong at all. In no way has it touched upon the merits at all, Milord. Now, this order passed by your Lordships, that envisaging that we are to file an appeal within 8 weeks, Milord, that is the only effective part of the order, nothing else. Regarding the correctness or the some faulty nature of the order, there is nothing on the merits at all. So, Milord, I don't know what is assailed before the Honorable Supreme Court. It's not in my knowledge, Milord. I have not seen the copy at all.
But that is exactly the point, Mr. Chakravarti. You see, I think judicial propriety, he demands that on coming to know of such a situation, like you said, you don't know what is there. We don't know.
But
Nobody
the
knows.
matter has not come up before the
Matter has
Honorable
not
Supreme
come
Court
up.
at all.
If this order has been assailed,
Milord, let the government give an undertaking that they will not release the matter. I will wait for as long as your Lordship and my friends want to wait.
I was about to say that.
I am the
my
beneficiary.
my-
I am making a statement, Milord, and as I pointed out, 23rd, Milord, it will probably be 21st, 22nd, or if my learned senior says 17, whatever it is.
But the matter has to be
Your Lordships
granted
are seized of the
consideration.
matter, Milord. I cannot do something,
but the
take
only-
advantage like that.
I think in that case,
We will not do any such thing.
in that case, then matter can be taken up by any other bench. Then.
End up.
This matter can be taken up by any other bench. Then.
Because, I'll be very frank.
this is
That
thank you
this
for
is one of those contested matters. It should not be one of the cases, Milord, where somebody says that this honorable judge, Milord, sitting in division bench, passed this order, and subsequently the matter again came up before the same court in a revision petition by one of the parties, and it was entertained. It should not be one of those cases. My honest.
Because you see, at this point of time, like Mr. Chakravarti has said, you see,
We none of us know,
we
Milord,
cannot
what is
connect all the dots as now.
Correct.
As of now. So we don't know when, at some point, like Mr. Paul said, at some point of time, it may transpire that yes, there is a direct correlation between the impugned order before the Supreme Court and the subsequent proceedings, including this one, which would, like you rightly said, it would affect the presiding
Because, well,
judge.
there are two difficulties. My learned seniors pointed out that there are two difficulties. Well, there's 206, there are two observations where my lords treat this as an original decree
Yes,
that your lordships have seen. So there is an effective pronouncement on the findings of the district judge. That's one difficulty. Prior to that, my lords have indeed gone into what are the findings of the learned district judge. That becomes a difficulty. I would humbly submit, my lords, that probably because to assuage whatever my learned seniors' concerns are, 23rd is far away, and otherwise also, my lords, we are before your lordships. I don't think, my lords, we'll try to jump the gun.
But Mr. Chakravarti, on the other hand, as far as this order is concerned, can you not go before the trial court and get it, stayed?
No, there's no way out.
Trial court is not seized of the matter now.
No, my lords have accepted that matter has culminated into the final orders passed by the division bench.
Oh, so that's an appealable order.
So your lordship is of the view that your lordship would not be taken
I'm
up.
not so sure how it will turn out.
Your lordship would not like to take up the matter. In that case, my lord, it may be put up before someone. Now, since that question has come to your lordship earlier also, and my friend also,
You can never.
But it should not be one of those cases. We are here to assist my lords, and we should not create a situation where something like this can at any point of time. My lords, that's my honest endeavor.
Heard Mr. Chakravarti, senior counsel appearing for the petitioner. Also heard Mr. N. D. Shulai, AG, for the
1 and 2, your lordship.
respondent 1 and 2, and Mr. Paul, senior counsel.
Or respond number 3, my lords.
On consideration of the submission made before this party, this court is of the considered opinion that this matter cannot be taken up by this bench. Forget it. We'll just simple line. As Mr. Justice will say, this is matter to any other bench, probably.
Abhilash.